Court of the country, as the Supreme Court, in fact, has sought the centre's response over a plea that was filed by the National Commission for Women, challenging a recent judgment of the Punjab and Haryana High Court, which had held that a 16-year-old Muslim girl can enter into valid marriage. A bench headed by Chief Justice of India, Justice Dhananjay Chandrachud, had granted 4 weeks to respond over this plea. And the plea also alleges that High Court order is arbitrary in law. Taking this across to my colleague Ananya for more. Ananya, just take us through all the details that you're picking in when it comes to this big response that has been sought by the centre, of the centre, in fact.
Well, remember that this is not the first petition. The first petition was moved by the National Commissioner of Protection for the Child Rights, that is the NCPCR, challenging these particular orders. Not only this particular order of the Punjab and Haryana High Court, but then other similar orders too, which were passed by various high courts of the country, when it was allowed that girls less than the age of 18 who were 16, 15 in various personal laws like that in the Islam were being allowed to have a valid marriage. However, the NCPCR first challenged it before the Supreme Court, and now in fact the NCW2 has challenged the said orders of the various high courts of the country, saying that this particular issue with regards to marriages of children is dealt at first by the POCSO Act, that is the Prevention of Children from Sexual Offences Act. And since POCSO Act is a special statute, that's the reason why all these orders, of whether we talk of the Punjab and Haryana High Court or we talk of the other high courts order, these are all arbitrary in law. In fact, we also remember that one of the high courts had recently said a very similar thing, that such a thing cannot be allowed because the POCSO Act comes into governance, and POCSO, being a special statute, overrides all kinds of personal laws, or even at times the criminal laws as well. So somewhere or the other, this would be the ground on which these petitions have been filed. NCPCR2 had filed this petition on the same ground. NCW2 had filed the petition on the same ground, and we might see that more petitions might come in. But then a bench headed by the Chief Justice of India, Dhananjay Chandrachud, and also P.V. Narasimhan, has now issued notice to the central government seeking its response within 4 weeks from now. And the hearing would be concluding on that. In fact, remember that on the NCPCR's plea also on October 17, the Supreme Court had issued notice and has sought a response. We are yet to await a response from the central government over this particular issue, and we'll get to know in a matter of time as to what would happen and whether these orders would be stayed by the top court or not.
Right, Ananya, thank you so much. Taking this across to my colleague Anusha as well, who's joining us. Anusha, when it is about the Prevention of Children from Sexual Offences Act, which is POCSO, of course, when that comes into play, any kind of personal laws are undermined, and that also is the big question, because now a lot of people are talking about this wading into the Muslim Personal Law Board. Just break that down for our viewers.
Addressing the elephant in the room is the Muslim personal law. There is no other personal law in the country that by custom allows the marriage of girls who are below 18 years of age. The practice and the customary law in Muslim personal law has been that once a girl attains puberty, especially post 15, she can be married off. There was an exception that existed in the Indian Penal Code as well, where it was said that any kind of sexual intercourse with a wife who's about 15 years of age is not rape. That exception existed. But there's a Supreme Court judgment that clearly lays down that if your wife is below 18 years of age, and if you happen to consummate your marriage presuming that the groom is a major, then in that scenario it's called a rape. There are various legal developments that have happened in 4 to 5 years. Of course, POCSO, as Ananya spoke about, is a very crucial aspect of it. That POCSO is largely about protecting the rights of children, and any kind of sexual activity with a child who is below 18 years of age is not permissible. Now, this aspect of the Muslim personal law is protected under the Shariat Act 1937, under the various heads that have been identified. Unless the Supreme Court takes a view that any kind of customary practice that violates the provisions of the POCSO, the 2017 judgment of the Supreme Court of India, is not valid in law, till then these practices will continue to thrive. And to add, not just the Chandigarh High Court, we have had roughly 2 to 3 high courts that have given different point of view when it comes to this practice of girls getting married under the age of 18. One more point I want to clarify, that the judgments of the High Court are on the particular facts of the case that were before them. the appeal before the Supreme Court is on the question of law. So there is no question of overturning the earlier judgments that were given by the High Court on the aspect of facts of the case. What the Supreme Court is going to do as and when the centre submits its response and there are arguments that happen in the court is to clarify the position in law. A constitutional debate has to happen, and Griha, you'd remember the triple talaq debate in this country was a big debate.
Yeah.
Once again, personal laws, not just the fundamental rights, but the child rights in this country are going to be the key debates, key contours to watch out for.
And I believe that needs to be important. You, however, were talking about the differing views by the various high courts of the country when it comes to this particular issue. If you can also break down that for our viewers, and essentially how there are a section we're talking about how this is an attempt towards going towards uniform civil code, because again, there would be too much of resistance that is going to happen when it comes to Muslim Personal Law Board.
That you've spoken about. One is that why is it that the different high courts have taken different views? At the end of the day, high courts are constitutional courts, court of record, so there should be a singular view that should come in. Well, the customary practice within the Muslim personal law has been that once a girl attains puberty, she can be married off. Marriage under the Shariat Act is governed by personal law. There is no statute that defines how a Muslim woman, what is the age under which she can get married. The customary law right now in this country is the legal position. So that is why you have some high courts which are saying, well, look, custom has been protected under the present statutory scheme, and that is why we have to respect it. What is the argument which is coming in from the other side? Uniform Civil Code, a very interesting aspect you talk about. It's one term that we talk about, but as the country moves towards one nation, one code or one law, you need to have an umbrella of issues that need to be addressed. One of the most critical issues is of marriage, divorce, and the most important one, to have a uniform age of marriage. If the Supreme Court, presuming a situation, says that forget the customary laws, if a girl is not 18, she cannot be legally married in this country, it is a step in the direction of a uniform civil code. So that's the direction in which the law and the jurisprudence.
Anusha, could you hold your thoughts? Let me actually bring in Brinda Adige, who's also with us at the moment. Brinda, what do you make of these varying views when it comes to the various high courts in the country, when it is about this basic thing that we have established over the years and it has been done to that? Why there is so much of difficulty when it comes to putting that fact together that any girl below 18 is not of marriageable age?
Absolutely right. There is no reason for any of them, whether it is the courts or the judges or the police or any of them, to be so patriarchal in their outlook, in their mindset. They still haven't grown out of all of it. These customary laws may be there, but there are central laws that are very, very clear. A, child marriage, irrespective of which religion the child belongs to, 18 years and plus. And when we are talking of children, we are talking of their education, we are talking of their health, we are talking of their right to enjoy that childhood. And that childhood is up to the age of 18. It is important, irrespective of customary laws, irrespective of traditional views, irrespective of customs that might be followed by any religion, caste or creed, to be very clear that children belong to the nation and that child has a right to enjoy all her rights. And if she is 16 years old, it cannot be just on the religion or their customary laws. That child has rights under the Constitution. That is supreme. So why is it that the judges think that I can allow somebody who is 16 years old to be married under the customary law, whereas the same child, if she has made a decision to have a consensual sexual relationship, may be filed under POCSO? Why is it that this mindset is not moving out?
Absolutely.
And I would put it down to this patriarchal mindset that seems to be looking at things differently at different points of time, where the case might be the same. She's 16, she cannot be allowed to marry. Simple.
Absolutely.
Even the Child Marriage Act has problems, but we need to sort it out.
All right. Brinda, thank you so much. Appreciate you joining us.